Hello, everyone. Hopefully, everyone can see my screen. I am presenting on relocation, notifying, objecting, and everything in between. So this presentation will give information about relocation, as the title says, if you are either the parent who is relocating or the parent who has received a notice of relocation. See if I can get this to work. There we go. All right. So parental relocation. You or your ex-spouse has a constitutional right to relocate. So there must be a compelling reason for relocating, and the move must be in the best interest of the child. So typically, um, you're going to want to first check your custody order. So the party's most recent court order for custody and visitation typically includes some language about relocation. When you initially drafted this document, you could have potentially changed this. However, it's not very common, but it is important to check this out to make sure that there already isn't some factors that are weighing in favor or against you moving or how far you can move. So that's a very good first step is to check your custody order. The next is that if you do not yet have a parenting plan, the custodial parent can move. So that means you're the custodial parent if you have the child more than 45% of the time. There's no parenting plan in place, you can move. So, however, you want to consider how that's going to look in the court's eyes, right? So if you're slowly or soon in the process of filing for a parenting plan and child support, notifying the other party in the court might be a wise decision, right? But it's not required. If you are not the custodial parent or if you have less than 45% of the time with your children, then you can just move. You don't have to notify the other side. Okay, there we go. So typical reasons for a move. So what are, some reasons that we usually find parents wanting to file a notice of intended relocation? So a lot of the times a new job, remarriage, educational opportunities, or family connections. So these are typically very positive reasons the court look at for relocation. If you're having to relocate for a new job that's higher paying, that you can better support your family, the court could see that as in the best interest of the children. Um, Again, remarriage. So there's more caretakers for the children. This can also be seen as the best interest of the child. Educational opportunities. If a parent is looking to better themselves or to further their education, that's always can have, further earning capacity and further potential benefits for the child. And then family connections. A lot of the times when you're going through divorce, one parent maybe doesn't have a lot of support around them. So being able to move to an area where they have more connections or more support, especially if they're, now doing a lot of the things on their own, can be very beneficial and in the best interest of the child. So notice requirements. So this is very important in terms of intended relocation. So if you're the custodial parent and you wish to relocate, and you're moving outside of the current school district. So there's different rules if you're staying within the current school district. You have to give at least 60 days notice, which might sound like a lot, but a lot of the times if you're, say getting a new apartment, buying a new home, those things take some time. So you put this in the process of your planning that you're going to have to give notice at least 60 days ahead of time. Better if there's more time. Um, if there's some reason the move becomes emergency, maybe you get offered a job and they want you to move there within the next couple of weeks, situations like that, you have to give at least 5 days notice, and then you have to explain to the court why you couldn't have given that 60 days notice. The move within the same school district, you must provide actual notice by any reasonable means. And another additional tip is that if you and your ex-partner are on good terms, you can always come to an agreement with the other party, and file that as an agreed upon order saying, my partner knows I'm moving, he's agreed to it, we believe it's in the best interest of the children, and you're just letting the court know what you're doing, but you can come to an agreement with your partner. And then in terms of moving within the same school district, the non-custodial parent, or the parent who doesn't have the child at least 45% of the time, may not object to the move, but they can ask for a modification of the parenting plan under RCW 2609260. Okay, delaying notice to prevent harm. So we said before, 60 days notice always, unless there's an emergency, 5 days. However, there is some situations that allow you to give no or less notice. So if the parent who's moving has been a victim of domestic violence and they're moving into a domestic violence shelter, you can delay notice for at least, I think, 21 days. And if you have evidence that you're moving to avoid clear, immediate, and unreasonable risk to the health and safety of you and your child, that can be another good reason to delay notice. And if the custodial parent believes notice may endanger the health and safety of a person or a child, the court may waive notice altogether. So that would be something you'd have to go in front of the court and explain your reasons why, you don't feel that it's necessary to inform the other party of where you're moving. So next, so if you file your notice of intended relocation, within 30 days, there's no objection from the other party. That means, they haven't responded to your notice, then your move will be permitted. So, and if you presented a parenting plan with that notice as well, it will be adopted. So this is very good to know because you can, if you filed 30 days later, you didn't receive anything, you don't have to file again with the court, you can just move. It is beneficial, of course, to then file an order allowing your move so that that is on record with the court. But after those 30 days, you can move. You are allowed to. See. All right. So there's 11 factors that the court looks at when they're considering if a parent's intended relocation. Did I miss this? I think, excuse me, I must have missed a page. Let me go back here really quick. Okay, so we have no objection, and then we have objecting. So if your ex-spouse does file a notice of intended relocation and you disagree, you have to file a summons and objection. And basically you explain from these 11 reasons we just mentioned of why you believe the move is not in the best interest of the child or why you disagree with the parent's move. And then you will set a hearing to have your objection and the notice of intended relocation heard. Okay, so the 11 factors. So the court's going to really consider these all equally. I'll kind of go through them quickly and then I'll have extra points about some of them. So the court's going to look at the strength, nature, quality, extent of involvement and stability of the child's relationship with each parent, sibling, and other significant person in the child's life. So here the court, right, is looking at that if the child were to be moved away, is this going to have a detrimental impact on the child that they're not able to have, a strong relationship with other potential siblings, grandparents, other family members, maybe even their parent, who the other one who is not moving. So that's a big consideration. 2, prior agreements of the parties. So if there's evidence that you and your spouse agreed to before that you wouldn't move within a certain radius, that's going to factor in. Disruption of custody versus disruption of visitation. So here they're looking at, will it be more harmful to the parent moving, not to move? or would it be more harmful of the person who has less time with the child? Number four, Section 191 factors or limiting factors. So these factors, are as part of a parenting plan, and this is another good thing about you should check your parenting plan before you go forward in this type of action. But these factors usually involve abandonment, physical or emotional abuse of a child, and domestic violence or sexual assault. So if any of those limiting factors apply to your partner, that will have a sway in the court's decision. So five is good faith versus bad faith. So the relocation statute will allow a move that isn't made in good faith for reasons like we talked about before: change in job, military duty, educational opportunities, poor health of a parent, reasons like that. But reasons that are a parent is relocating in bad faith will be denied, such as one parent wants to exclude the parent from the other parent, or hatred of a parent, a desire to conceal evidence of child abuse, or using the move of a threat as force to the other parent to, maybe take away their time or increase child support or something in that way. So the court will consider those if either party has evidence towards them. Number six is impact on the child. So the court, again, is looking at the best interests of the child. So this is an important factor. They'll look at the age, developmental stage, and needs of the child. Teens, for example, may have a lot more difficulty moving than an infant may. They have sustained relationships, they have a school they're probably in. There's different things to consider than a newborn. The court will consider the effect of a proposed move on the child's physical, educational, and emotional development. And it will also very strongly take into any considerations of special needs or specialized medical care. So say a child is in a large city that gets specialized treatment. If a parent is trying to move away to a smaller town with less ample resources, that's something the court's going to take into consideration. The loss of contact with relatives after a move or additional contact with special loved ones will also be considered in this factor by the court. So next we have quality of life. So this includes resources, opportunities available to the child, neighborhoods, schools, sports, activities, all those things. So we're looking at the current environment or neighborhood the child is in and where they're moving to and how those compare. Alternative arrangements to foster relationships. So this factor kind of looks at how, if the child moves, how can maybe the other partner still maintain a relationship with their child, right? And the court's going to consider this differently for different types of moves, of course. So if a child or a parent and a child are moving an hour away versus parent and a child moving states and states away, those relationships are going to be maintained in different ways. But we do have Skype, FaceTime, different ways now that technology really helps you maintain those relationships. However, we do also understand that it's not the same thing as spending real in time person with your child. So number 9, alternatives to relocation. So is there anything that can be done that, the parent has a reason for moving that can be changed to help them live a better life here where they are? 10, finances and logistics. These are very important considerations. One topic that is often overlooked is the cost of transportation to maintain regular visitations. So if you're seeing your child 3 or 4 times a week and they move a couple hours away, that's going to be a big factor in gas, driving, those kind of things, upkeep of your car. Those are going to be important considerations, especially if the parent is proposing to move states away where you'd have to fly or the child would have to fly. That is definitely an important consideration. 11, time left before the trial date. So in relocation cases, the trial is usually held within 60 to 90 days after the objection to relocation has been filed. The relocating party often needs to file a motion to allow the move before the trial date due to practical issues like the start of a new job, the beginning of a school year, etc. So the court at such a motion will take into consideration whether or not it is practical to delay this actual move until the hearing or enter an order allowing the move until the trial can be held. So a lot of things to consider there. The court takes these decisions very seriously. So next we have a motion for temporary relocation. So this is kind of what we just talked about briefly, but the court may grant a motion to permit a temporary relocation pending trial, and they can also allow the move. And in the alternative, the objecting parent can file a temporary motion to prevent the move. So if the parent has a lot of concerns within those 11 factors and they want their child to stay here until a judge makes an order on the relocation, then they can file that motion to keep the child here. So there's a lot of questions that can come up during a relocation. So it's really important to have an attorney who kind of understands these sorts of situations and can help guide you through this process. So if you have any questions, please feel free to reach out. Thank you.